hey, it's worth a shot. So I told Travis, after he had the affidavit, no matter what you do, anytime the word contempt, because contempt is a dangerous charge, anytime the word contempt comes out of that judge's mouth, you must immediately apologize. 4 times that judge came over the bench and tried to hold him in contempt, and 4 times he apologized, and every time that judge sat back down and just glared at him. Not one time did he hold him in contempt. Now, Brandy went back to court the following week for the hearing that was rescheduled. And he sat there, and he sat there, and he sat there. And finally he went out to the clerk's office, and he says, is
dismissed.
Yeah. Is this case going to go forward? What case is that? And he told them, and they said, that case has been dismissed. Okay? Now, that was using the affidavit of specific negative averment. Okay? When we're saying that they don't exist. Now, what do I mean when I'm talking about that? Well, under Rule 9A of the Rules of Civil Procedure, Rule 9A, Rules of Civil Procedure, by the way, is the prescribed method of complaint and remedy in the court system. Okay? They have to have rules. Now, everybody has always taken the position that how can you deny something exists and then use those rules of the entity that doesn't exist? Good point. So we don't use the rules by name, although I have done so in experiments, and the same thing happens. I now answer a civil complaint of any kind right off the bat, if I'm in it from the beginning, with an answer with a specific affidavit of specific negative averment in support, under and pursuant to Rule 9A. I did this for my neighbor. She had a couple doctors sue her for some medical bills that the insurance company wouldn't pay, and the attorney tacked $200 per count on for $800. And she says, you know, it isn't about the money. I'll pay it if I have to. I just want to mess with them. Can you help me? No. So Rule 9A lays out everything you need to know about especially little stuff. Okay? But I've used it in big stuff as well. Federal stuff. This is one of the first things that I do. A, capacity. Now get these words, okay? It is not necessary to aver means to allege, the capacity or authority of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of thugs, persons, that is made a party, except to the extent required to show the jurisdiction of the court. Now, what did that say? It says that when a plaintiff of any sort creates an action and complaint against you, the only thing they have to grant or allege is jurisdiction. That's why the first paragraph of every complaint is a jurisdictional statement. The court has jurisdiction because. Okay? What is that? That's consent. You're creating a contract. You pay a fee to the judge. Now remember this. You pay a fee to file a complaint. You pay it to the clerk. Okay? And so you're charging the judge on one side. Okay? Now, then there's supposed to be an answer. And when you file an answer, you have to pay a fee to the clerk, and you charge the judge on the other side. And he agrees by contract and consideration to hear the matter in front of him. But it's not commercial. Okay? Now, the party bringing the complaint, the plaintiff, has to grant jurisdiction to the court to hear the matter. So that's the first thing they do. However, they don't have to allege or aver their capacity or authority to do so, or that they have a legal existence. That's just granted to them. By virtue of you filing a complaint, you exist. But there's more to the story. Now note that we had capacity, authority, existence. Now listen to the next sentence because it gets turned around backwards. When a party desires to raise an issue as to the legal existence of a party, of any party, or the capacity of any party, or the authority of a party to sue or be sued in a representative capacity, get this now, the party desiring to raise the issue shall do so by specific negative averment, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. That's an affidavit. Okay? And what you're doing by affidavit is saying you don't exist, and neither does this entity you're suing. Because that entity's in all caps. Bring him forward. Bring my name forward in all caps. Where is he? Okay? That's what you're saying. They can't do it. It doesn't exist. So now you've shifted the burden. You've answered. And you've answered by affidavit. Now you have shifted the burden of proof to them because you have the superior proof. You have the best claim. And it's that proof that enables you to win. Most of the time we never hear from them again. Okay? They just go away because they cannot come back with an affidavit that says that entity that they sued, they may be able to produce the corporate documents for themselves. Let them produce the corporate document for that straw man of mine that they sued. I want to see those papers. Okay? Because I want to cross-examine that guy. I want to know what he's doing with my name and how he got it and who his mother and father are. Okay? Now, I go from 9A to 9B. And 9B is fraud, mistake, condition of the mind. In all averments or allegations of fraud or mistake, the circumstances constituting the fraud or mistake shall be stated with particularity. Which means that I'm going to create an affidavit that specifically says why this is a mistake. And I'm going to create an affidavit that says why this entity doesn't exist. And I totally shift the burden to them. Okay? Now, if you go back a couple paragraphs to Rule 8. Rule 8A is claim for relief. Rule 8B is a form of denial. Rule 8C is affirmative defenses. And Rule 8D is effect of failure to deny. Now this is critical because when you get a complaint and you don't deny, you admit. Well, guess what happens? When you get a complaint and you answer with specific negative averment and they don't respond, they admit. And once they admit, they're barred. Okay? Here's what it says. Averments in a pleading to which a responsive pleading is required. An affidavit is a responsive pleading, and a responsive pleading is required, other than those to the amount of damage, are admitted when not denied in the responsive pleading. So if they file a complaint and I put in an affidavit of specific negative averment and they don't respond, they said, yeah, he's right. Now where are they going to go? They're done. Their complaint just went out the window. And that's what's been happening. Yes?
Do they have to respond by affidavit?
Do they have to respond by affidavit? Absolutely. Okay? Whenever someone puts forth an affidavit and no one responds by affidavit, that affidavit becomes the law by contract.